Joe. Yeah. It's Joe, no Joe. Let's go. Joe, no Joe. Chicken Joe, no Joe. Joe, no Joe. Niggas Joe, no Joe.
Choke no joke. Good morning. It's 9/11. You know what 9/11 brings back those type memories. We ain't gonna get into that today. But we are back in court for the Young Thug trial. You know what it is, the Ysl Rico trial. Tap in. All right. The court is about to be in session. Choke no joke, you already know. Wake up, wake up, wake up, wake up, wake up. It's the 9th of it's the 11th of the month. Grab your bags and come on. It's the 11th of the month. Grab your bags and come on. All right, we here, y'all.
Okay. All right, y'all come on up, please. And Miss, up to the podium. One of you can come on up and the other one can just sit in one of those seats right there till it's your turn. So you are Miss Borden?
Yes.
Okay. And you want to, what, live stream? Or what do you want to do?
Yes, I wanted to do a live stream in pictures and take notes.
Okay, well, you're certainly welcome to take notes. That is not a problem at all. In terms of live streaming, we've already got a lot of different cameras going, and so you are welcome to pull from either of the streams that's already occurring. All right?
Your Honor, I would like to, if it's okay, I would like to submit some reference letters that I have from a civil rights attorney and also the news media channels that I've been working with over a decade.
You certainly may, and it absolutely has nothing to do with who you are or who you represent or what you're going to say. It's just that we've already got so many pieces of equipment in here. It just becomes kind of a security matter and a distraction to the deputies and frankly to me to have to keep trying to keep track of that many more pieces of equipment and people handling them. Had you been the first person, I probably happily would have given you the right, but it's just, you know, we've already kind of got everything set up. There are two different streams that you can pull from. So yeah, I'm happy to take them. That's not the reason for the denial. It has nothing to do with who you are.
And can I say something, please?
Sure, absolutely.
So my concern up under the Rule 2022, and I've been doing this over a decade as a civil rights leader, and also an awarded community advocate where I'm a former mayor. So I am aware that there are other cameras, but with the case of this nature, I feel like the community deserves different angles and different perspectives. So while they do have a camera and while the camera is on, there's still different perspectives and angles. That footage goes through some other entities that I'm not a part of. So even if I was to pull or jump on their train, that is separate from me as a civil rights leader and wanting to share with the community and making sure that it is a fair trial.
Okay, so I don't know if you mean angle as in position that you would take in your reporting or angle as in camera angle.
When I say angles, meaning that, for example, there's a camera on right now,
right?
That I'm looking at. So if I want to report something or show something and it's not from his angle, that means if I have to jump on what he's doing, I'm relying on his footage only.
So you actually literally mean camera angle.
Yes.
Okay,
Yes,
which
camera
is
angle.
either gonna be
Yes.
on the witness, the judge, the state, or one of the defendants.
Yes, but it's still the reliance of me depending on the footage. And I'm pretty sure the footage that they have, I know of any other time I've worked with 2-5 and 1146, there's an approval process for that footage. And I will also be dependent on that sometimes as well. But if I'm able to stream myself, then I have more control of that footage.
Okay, well, if you want to go back in the media room and film from there, you may do that.
Okay.
Okay,
Okay.
all right. All right. Anything else?
No, Your Honor.
Okay, thank you. All right, and Ms. Hall. Good morning. How are
Good
you?
morning. I'm fine. Thank you for your time today.
Sure. And you want to do still photography and
Yes, ma'am.
audio?
Yes, ma'am. My situation is a little bit different, even though I do have a YouTube channel and I can pull from the pool, which I
Right.
have done.
Okay.
Because I'm a freelance blogger, I can't depend on the pool for still images. So my situation wouldn't be setting up tripods or anything of that nature. And I would ensure the integrity that I'm affording, especially from our seating that we have, that we don't compromise any integrity of jury or anything of that nature.
All right, and you'd be able to, you say still photography and audio, you'd be able to pull audio from one of the
I
pool
can pull,
sources
yeah, I can pull
already.
audio from pool.
Okay. And what kind of equipment are you talking about?
Sony AX50, one of those type of still cameras.
Does it make any noise?
I will make sure the settings are off.
All right, you're gonna need to be wherever it is that the deputies put you,
Yes,
and
ma'am.
you're not gonna be able to move around.
Yes, ma'am.
Okay. All right, and what's the camera?
I have a Sony AX1, Canon C50. So I'll work with the settings and make sure which one will be dependable on the fact that it will make no noise.
All right, and you'll be the one operating?
Yes, ma'am.
Okay, thank you.
Thank you.
All right, Ms. Abbasi, did you just get alerted this morning that you were gonna be the one covering court?
Is it granted?
Yes.
Okay,
We'll
thank
get the paperwork out to y'all probably sometime today.
Okay, thank you so much.
Okay. Well, since you didn't know until, I guess, a few minutes ago, nothing you can really do about it other than get here as soon as you could. So I appreciate you doing that. All right, does anybody have an issue with anything that occurred over the course of the evening that y'all need to bring up with me? Or is everybody fine? Yes, sir. Well, Mr. Sharp stood up first.
Your Honor, we came in today
to provide me with anything you found between yourself and any of the attorneys for co-defendants who have entered pleas?
Judge, the court gave me until noon.
Oh, okay, that's fine.
Your Honor, I would like, with permission of the court, to check with Ms. Winfrey's exhibits to see that 460 is up there, because I took one stack, but
Okay.
460 was not.
You can check.
Thank you.
And were the parties able to come to any agreement or partial agreement with regard to any of the exhibits that were tendered at the end of the day yesterday?
No, Your Honor,
Y'all haven't what?
we haven't discussed that, redactions. I have gone over the exhibits themselves, and I have a legal argument that I'd like to present to the court regarding 104.
Well, I'll hear it after lunch then, because I instructed you to get with the defense so that you could see whether y'all could come to any sort of an agreement. So if they haven't seen it yet, then I will give y'all the lunch break to accomplish what you were supposed to accomplish yesterday evening.
And may I inquire what the court inquired, whether 460, which was a document that I believe at the end of the day,
Mm.
some counsel for defense were looking at, I believe that I retrieved it, but I believe Mr. Sharp may have had it.
I don't know. Does anybody have 460Y? Can y'all check? Sometimes it's hard to keep track of all the documents.
Now, there was several documents that, someone, I think it was either myself or Mr. Adams, put into the documents, that folder for the documents.
Identified only.
Yes, identified only, I don't know.
Yes. All right. Do you locate it? Were you able to locate it, Ms. Love? Okay. Well, I'd imagine that would be easy enough to reproduce. It was just printouts from emails, right?
It was Mr. Wright's emails. Haven't provided a hard copy.
I mean, yeah,
And actually,
I'm sure I have a copy of it since you gave it to me, if that would help.
it would, if the court doesn't mind allowing us that copy, court's copy, I would.
Okay.
Return it back.
I don't think I've made any markings. Well, I have made a marking on it, sorry.
It would actually help us to recreate.
Just, yeah, look at it to recreate it, that's fine.
Thank you. Thank you very much. Thank you.
Nobody was able to find a 460Y anywhere? Okay. Has anybody checked up in that podium area? Okay. All right, well, it can be reproduced. It's not the end of the world if we can't find that particular one. All right, turning to the issues we need to decide. Ms. Abbasi, your co-counsel had filed a motion limine regarding autopsy photos from the Holmes murder. Is the state ready to respond to that?
Yes,
All right. And Ms. Fossey, do you want to make any argument?
At this point, no, Judge, the motion is largely self-explanatory.
All right.
I'll let Ms. Sullivan.
Thank you, Your Honor. Good morning.
Good morning.
Your Honor, when we get to presenting this act, which is count one, Act 79, the state intentionally did not include the medical examiner. This is a case in which Mr. Ryan has been convicted of the murder of
Right.
Jamari Holmes. And so it is only the state's intention to bring in 3 photos, and I have a copy of those 3 photos that I can show Ms. Abbasi
All right.
through
Well,
the lead detective in order to minimize that level of testimony. And so we do not plan to stipulate, but we've selected only 3 photos that we intend to
all right,
introduce.
let's see what they are.
And I can bring them up to the court. For the purpose of this hearing. Yes. And for the purpose of this hearing, Your Honor, the state's gonna label them states 1 RR, states 2 RR, and states 3 RR.
And what do y'all plan to present with regard to, just kind of a general overview, the evidence that will establish that Act 79?
Generally, Your Honor, what occurred leading up to the homicide of Mr. Holmes, which was a luring of Mr. Holmes to an apartment complex that Mr. Ryan and Mr. Blaylock then, we believe, ambushed Mr. Holmes along with 2 other victims. They were in a vehicle. Mr. Holmes was shot, and then they fled. And then subsequent to that, there were Instagram postings, Facebook postings, or excuse me, social media postings regarding YSL, very close in time to the murder of Mr. Holmes, Your Honor.
All right, and how many witnesses are you going to utilize?
For that act, so we have 5 witnesses.
Who are they? And what will they generally testify to?
You're on that 5 is a marked reduction from the original list of witnesses. We did not intend to retry that murder.
Well, that's good to hear.
Your Honor, 5, the witnesses for that act are Ms. Sharon Latner's, Starry Holmes, who's the mother of Mr. Holmes, Mariah.
An eyewitness?
No, she is, just would be able to bring in his in-life photo.
Let's
And
figure out a
talk
different
about
way
Mr.
to do
Holmes.
that, especially given that this is not even the trial of that case.
And speak about Mr. Holmes and who he was. Okay.
I have a relevant objection on that.
And that would be sustained.
And to talk about his involvement, who he is prior to this murder happening, he was a juvenile. I don't know if any of these other witnesses would be able to do that. Mariah Smith was someone, I believe he had just met recently, who helped set up the robbery that ultimately led to his death.
Okay, all right, have you moved on to another witness now? Is Mariah Smith another witness or?
Mariah Smith is another witness, Your Honor.
So Mariah Smith would be able to say he was a juvenile, right?
She doesn't, I don't believe she really knew Mr. Holmes.
How old was he?
substantially. He was 15 at the time of his death.
Mm-hmm.
Um,
And
yes.
Miss Latner's backing up. She would, what, introduce a 911 call?
Yes.
And what's that gonna say?
But it was the initial reporting of the shooting. So it was at the time, the time of the shooting.
Just
framing
one
it
call?
I believe just one call. Your Honor.
Judge, we would have no objection to the call.
Okay.
admitted where, the witness says he'd like to speak with police and police don't speak. No problem with that call coming in.
Is that the call?
I don't think that that's the call. I think that the initial call about the shooting.
That may be a different call.
Yeah.
It's a different call.
Okay.
And
Okay, so,
the witnesses are our skeleton version of what we can present to show absent, because we cannot just put in the certified to show the facts of the case. So we're trying to put in.
well, I mean, sure, the fact that the murder wouldn't get it as an overt act that is a part of RICO. So I understand you need to do a little bit more than that.
Right. And so we're trying to, we've scaled back. We had these
Okay.
witnesses.
All right, I don't
representing
need to
one of-
hear what it was gonna be at one point in time. Maria Smith is going to say what?
She was one of the two young ladies who lured Mr. Holmes and his three friends back
Okay.
to the location, or to the location.
All right,
Then we have one of the two other victims. We don't plan on calling both of them.
okay,
So that it'd be either Mr. Uten or Mr. Mitchell.
all right,
Then we have the lead detective on the case, who is Detective Hogan. Then we have Mr. Mike Sprinkle, he further brought the
He'll-
additional evidence of some of the social media,
Social
that
media.
came in later. And then last, sort of,
so 7, not 5.
so Wooney Lee is one of the co-defendants or co-conspirators in this case. He is coming in during this portion, but he was present during the initial trial of Mr. Ryan and posted some social media postings with rat emojis when Miss Mariah Smith initially testified in that trial. And so he's coming in that portion, but he's not actually a part of what will prove the actual act, but that's why he's included.
And Your Honor, we do need some clarification whether it's going to be Mr. Uten or Mr. Mitchell. We've been in contact with the state about going through the evidence we've offered for these witnesses, what does or does not need to be redacted. Mr. Uten's interview is.
Can you spell that last name?
Yes, Your Honor, it's OOTEN.
Okay.
His interview is maybe about 20 minutes, half hour with some quiet time, and Mr. Mitchell's interview is several hours long.
Okay. When are we gonna get to this part of the trial?
Your Honor, we would believe that we would get to this portion of the trial probably early October,
Okay, so fairly soon.
fairly soon. Yes,
All
Your
right,
Honor.
when will y'all know who it's gonna be?
We should know within the next few weeks, within 2 weeks, Your Honor.
Your Honor,
Well, 2 weeks from now is the end of October, so. I mean, the end of September, trying to rush that along.
Your Honor, we do want to have an opportunity to go through the state what evidence they believe will actually be admissible. Right
Okay.
now, we've got more than 50 pages of Instagram records from Mr. Blaylock, co-defendant, not testifying, more than 200 pages from Mr. Ryan. Those are obviously issues we'd rather not sit down with the court and go page by page, but if we need to, then we will.
And Your Honor, I believe there was some preliminary conversations, and we do intend on furthering or finishing those conversations with Ms. Abbasi and Ms. Deloy.
Okay, well, that probably needs to get done before the end of next week.
The state could respond to our email. if we want.
Can y'all,
We can. We've also found it fruitful to communicate via phone, which we have done and will continue to do at times that are convenient for either Mr. Bassi or Mr. Williams. That communication has not stopped. I think there were some issues, but we've done that as well.
all right, well, try to do it in a timely manner, please. Okay, let me see the photos. And the photos would come in through the detective. Did you get copies too, or we just? Is this third one like post incision, or is that the exit wound?
That is the Entrance wound. Your Honor.
Entrance wound?
Yes, Your Honor.
Your Honor, one of our objections is I don't know who's going to be able to answer that question. I don't believe the lead detective is qualified to explain what type of injury you're. We don't believe the detective will be able to lay the foundation. Oh, I'm sorry. We don't believe the detective will be able to lay the foundation for these photos.
All right.
We believe that with some conversation, he can talk about the fact that the victim was shot in his head, that is the victim, that he was it was his homicide that he was investigating. The picture, which I believe is 2RR, with just the area in which the
Before it's shaved.
before it's shaved, I believe that he could talk about where the bullet was, or that he was shot in the head. And then the last photo, I'm not sure if he'll be able to say it's an entrance wound. We'd have some further conversations with him regarding whether or not he was present during the autopsy or not, and whether or not he
Do you think that there's any chance he was present during the autopsy?
sometimes they are. Sometimes they are. I'm not saying that he would, but sometimes they are present during the autopsy.
Was he present at the scene before the body was removed?
Yes, Your Honor, I believe so. I believe so, but I need to ask. Ms.
Okay, well, you'll.
Ms. Love. Do you know if he was present?
Your Honor, I've got, based on the police report, the officer received his phone call at 6:07 requesting assistance to the homicide. The victim had already been taken to Grady, and ambulance 571 was pronounced dead at Grady at 6:10.
Okay, so if he was at the scene, he wouldn't have seen the victim at the scene, so that wouldn't be helpful with regard to these photos.
And Your Honor, we were trying to avoid the ME, so if we can have some stipulations to that, or we can have the ME come in for
All right.
innocent purpose.
Why don't y'all get together? I'm gonna hand these back for now and come up, maybe you could come up with all sorts of stipulations. So we'll revisit that.
But we are just trying to reduce the need of having to call the medical examiner.
Say that again.
We are just trying to reduce the need of having to call Dr. Sullivan.
Well, there's no necessity to call him or her. Can't remember. Also. Okay. Yes.
On that, I'm not saying I cannot find my list. I cannot remember if the state is moving for the verdict against Mr. Ryan into evidence, but I would be objecting under 24-8-803-22. And I'm just reading from a case, a jury's verdict that the co-defendants were guilty as a hearsay statement. The exception to the hearsay rule provides for the admissibility of the final judgment of guilty as to a felony, but not including when offered by the government for purposes other than impeachment judgment against other persons other than the accused. And then I just pulled up 24-8-803, and then it's subsection 2.2, and it specifically says the same.
What's with the state's plan with regard to that?
I just want to put you on notice so we don't go into it.
As to the conviction itself, Your Honor, I believe that it would not be improper, and I'll reread the case law on that. I don't believe that it would be improper to limit, as the court did earlier with the conviction itself, of the witness. Actually, because it was not a statement that he made, actually, Your Honor, I think that it would be admissible against all of them. It wasn't a guilty plea, so it's not a statement that the
Yeah, it's any judgment of previous conviction is what 22 covers.
okay.
So
So to the extent that the actual certified is tendered, then if it is the fact, and it could, we don't argue that it, it's probably the fact that that certified alone is admissible only against Mr. Ryan. But the facts of the murder itself and the circumstances and what he did, we'd argue are admissible against all of the defendants in this case. So,
the facts,
yes.
right.
Not the actual certified, but I was speaking Ms. Hilton, not the court.
I can't hear you. I mean, I know that mic doesn't want to behave properly, but maybe you can borrow the witness stand mic if that one was even working yesterday.
It wasn't. I'll try to hold it carefully. So the certified itself, we may have no argument regarding that being used and there being a limiting instruction as to the certified itself against Mr. Ryan only. But we would also ask and would craft and present to the court an alternative if there is an instruction that is requested that includes language that the facts that are presented that the jury takes as evidence are admissible against all of the defendants, including any postings or statements that Mr. Ryan or Mr. Blaylock made as a result of or in furtherance of that act.
Okay.
It seems, Your Honor, to play all that while the court can't hear us. It seems that while the court can't pick us up, somehow or another, the person who is running the camera, he hears all of our.
All right, well, that is irrelevant to me.
I know.
I mean, I'm not worried about how the media can or cannot hear. I'm worried about whether the parties in this case and the court and the jury, when the jury's here, is able to hear.
Yes.
So they'll just have to deal with it.
Because the issue was they could hear our internal.
Oh, they can hear what y'all are saying there at the, so that's getting picked up?
Yes.
Well, that's problematic.
With all the mics off.
Okay, so y'all gonna need to adjust your microphone in a way that is not picking up attorney work product conversations. Can you do that?
You just get the fees from the courthouse.
Okay, well, then you're not gonna be able to to do the audio if it's picking up attorney work product conversations between the counsel at the tables. I don't know what to, I mean, some adjustment's gonna need to be made. I doubt if they can hear it all the way over there, but what all's getting picked up?
Just when we were having a conversation.
The state, Well, I appreciate that, but I'd imagine it's gonna be pretty constant that they're gonna need to talk amongst themselves.
And it's happened multiple times in trial that people will text us, they can hear your conversations at the table. So this is a repeated issue that's been.
Okay, well, thank you for bringing it to my attention. Where's your feed, like your audio feed coming from? Where's it getting picked up from? Do you know where the mic is?
No, it's connected to the core system, so whatever feed you are being represented.
All right, Ms. Persfield, can you get IT to get on that issue, please? She's watching on Zoom, I assume. Maybe I should text her too or email her too. Instant message her on my computer. Give me just a second. So you're attached to what, the Zoom?
Whatever feed the court gives.
I don't know what feed the court gets, but all right.
Ironic when the court came here.
All right, Ms. Persfield's reaching out to IT about it now. All right, do we want to turn to where we left off when we were last here, which was trying to sort out the nested hearsay in one of the wiretap conversations?
Your Honor?
Yes.
Before we turn the page, could I just get some clarity? Because I'm confused. The state, I believe, indicated that they thought the facts of the murder case involving Mr. Ryan were admissible in this trial, but the conviction wasn't. But then they started talking about limiting instructions.
Mhm.
And I'm confused. Are they maintaining that the jury verdict from a separate jury is admissible against in this case? Or are they abandoning that and saying that they're going to get into the facts of this case?
Go ahead.
We are saying, Your Honor, that the conviction itself is admissible and will be tendered, and that an instruction should be given that the certified that we intend to introduce that conviction should be considered against Mr. Ryan only.
Oh my.
But the facts of the murder and what happened should be considered as evidence if they choose to, believe it, against anyone currently on trial.
All right, so it sounds like you do intend to introduce the certified copy of the conviction,
Yes, Your
and
Honor.
that would be accompanied by a limiting instruction that is probably similar to the one I gave before, that that can only be considered against Mr. Ryan. Of course, he's charged with the RICO count, right?
He is.
Okay. And then they would present facts which they would hope to be able to establish not only that a murder occurred, but that the murder was part of the RICO conspiracy.
We would introduce.
And that would be admissible against everybody charged with the RICO count.
We would, right, much like some of the unresolved murders that are in the indictment. We would be introducing the evidence that Mr. Ryan and Mr. Blaylock did it, and what connection we believe it has to YSL and what they did to promote YSL before, during, and or after. So that evidence we believe is admissible against, well, we know it's admissible against everybody on trial now.
Okay.
All right, does that clarify?
Well, it clarified that we do not have an agreement, and I'm diametrically opposed to what the state is saying. Couple things. First of all, that verdict was not the verdict of the fact finders in this case, which
Sure.
we chose and are our jury, and that's Mr. Stillwell's jury.
All right.
Also, Your Honor, I'd like Your Honor to know that Mr. Ryan's case is currently on appeal. It's not a final judgment. It's on appeal.
All right.
And I guess I defer to Mr. Attorney Steele on this, because as I understood it, he was going through the law that would prevent them from presenting this as evidence. And it is evidence against us.
I'm sorry, when you say this, what do you mean?
The
Fact-
conviction.
Conviction?
I'm not worried about the facts. I understand the facts, but the conviction, and they want to use it as proof of an overact, which as an
Only
element.
as to Mr. Ryan
Well,
is what they're saying.
well, no, they just said it against everyone as far as count 1 to Rico.
The facts that they're going to present, not the conviction.
Okay, well, I don't, as I understood the case law, as Mr. Steele was reciting it, and maybe I'm wrong, but I thought we were at an understanding that they could, that's exactly what they could not do, is take a verdict from another jury and use it as substantive evidence against anyone in this case.
No, they can use it against, I think that they can use it against Mr. Ryan.
Well, they're using it against him for a RICO. This was not an admission by Mr. Ryan. This was not a plea of
No,
guilty.
he was found guilty. It's still a judgment of conviction.
Well, it's not a final
And-
judgment. It's on appeal.
Pendency of appeal doesn't matter in terms of admissibility. It's right there in the statute.
Okay. Well, I understood the state said two different things, and so I was seeking clarity. I'm opposed to it. I'm stating my objection. I don't believe that if Mr. Ryan is charged with a RICO count along with my client, and they have the exact same element, and the jury's instructed that they need to find the commission of one of the overt acts, and they're told to consider the jury, the finding of a separate jury against Mr. Ryan. I don't know how they separate that. I don't know how a limiting instruction separates that and protects Mr. Stillwell's rights, and they wouldn't accept that same jury verdict against Mr. Stillwell and others for count 1. I don't think a limiting instruction would be sufficient. I think they need to prove that case.
I think we have some case law that addresses that subject. I'd like to flesh it out given Mr. Sharp's objection, but I'd preliminarily point the court to United States versus Pelullo, Pelullo, 14 F 3rd 881 at 888. It's a Third Circuit 1994 case. And it specifically speaks to prior convictions being routinely admitted into evidence at subsequent RICO trials as an ordinary piece of evidence. A judgment is subject to evaluation by the
Slow down a little bit.
Oh, I'm sorry.
A judgment what?
As a judgment, I'm sorry, as an ordinary piece of evidence, a judgment is subject to evaluation by the fact finder, who can accept or reject such evidence as it deems appropriate. Also, United States versus Tocco, Tocco, 200 F 3rd 401, in site 417 to 418. It's a Sixth Circuit 2000 case, finding the district court's admission of evidence of a co-defendant's prior conviction permissible to establish RICO predicate here it says because the evidence was not used as collateral estoppel. But again, these are cases that I would need to flesh out. These are just preliminary cases for the court's consideration, given the argument that I'm hearing Mr. Sharp make right now, that we would point to as a starting point.
All right. Well, we're gonna have to get that sorted out fairly quickly if we think that within the next 2 weeks, we're gonna get to this,
Yes, yes.
or so, 2 weeks or so. Okay. So, Mr. Shar, are you clear at least on what the state's position is?
Now,
Okay.
thank you.
All right, we ready to turn to that Garlington wiretap? Hmm? Oh, yeah, I'm not deciding that issue right now. We'll come back to that. Sure. Evidence before the Garlington wiretap evidence? Okay, then maybe we need to set aside the Garlington wiretap and deal with the evidence that's gonna come in against Ryan. Okay. We'll wait till he gets back, but just trying to figure out which thing to turn to next. Okay, that's fine. Let's take a quick break for anybody that needs to run to the restroom. Maybe we should turn to the evidence that's gonna come in on Mr. Ryan's, on that. That'll happen before the wiretap evidence.
Yes, Ryan, I thought, are you talking about the email that Miss D. Williams sent?
I don't know,
Because
did she send one recently?
I thought Ms. Abbasi and that was what we talked about a few moments ago. You said, the two of you need to get together by the end of next week to go through those items so that we wouldn't have to use the
Okay.
court's time to do that.
So I guess it was, yes, Ms. DeWilliams' email from, well, it was a long time ago, about all of the exhibits.
Yes, Your Honor, and
Okay,
I'll
so
get with
y'all
Ms.
will get
Abbasi
together on that.
yes, to discuss a time.
Okay, and can you remind me, did the state decide that y'all can, I guess, concede that Mr. Ryan's statement to police is inadmissible or no?
Yes, we can use that.
Yeah.
Okay, all right. I thought y'all had conceded that, but I hadn't written it down on this. So. Let me put that in the issues that have been dealt with folder. All right, so do we want to do,
We could talk about the busing staff.
the what?
One of the matters that were addressed in an email by Mr. Ryan's counsel was the Harold Bussey stabbing. I believe Mr. Abbasi or Mr. Williams moved in limine regarding excluding the evidence that Mr. Bussey was stabbed. Our argument about it being intrinsic, the court last said, or gave Ms. Abbasi an opportunity to give case law stating that things that were used after the fact, Ms. Abbasi can correct me where I'm wrong, but acts that occurred after indictment could not be presented. And I think in her brief, she indicated that, I don't want to speak for her, but I think she indicated that she found no case law in support of that position. So we're prepared to argue
Okay.
that. I'll let her speak.
Yeah, we submitted a brief and went through each of the possible admissible purposes. And as far as completing the story, something which happened after the indictment was called in there. However, something which after indictment certainly could be part and parcel of inextricably intertwined in the same practice circumstances, but that's not the case. So the brief does put out in there that the intrinsic acts the state is seeking to admit does not meet any of the criteria or exceptions, whatever you'd like to qualify it as, for those acts to be admitted. I don't know if the state is planning to respond. I did submit that separately.
Right, and I read it and I marked on it, and now all I need to do is find it. I need somebody to keep me organized. Does the state have a response?
We do, and
Did y'all file a response?
No, we made an argument that essentially is the same one we're going to make today, but based on what they've put forth, we'll respond specifically to the arguments that are asserted, put forth in Ms. Abbasi's brief. I think we presented case law, and I think that the court saw that case law. I won't speak for the court, but I believe the court saw and was satisfied that case law does say that acts occurring after indictment are not precluded as evidence of the conspiracy.
Right, no, agreed, but it's two separate issues. Right. I mean, if it's gonna be, they're not precluded just because they're post-indictment, but if they're gonna be admitted as intrinsic evidence, then they have to fall within one of the things that makes them intrinsic evidence, that it's the same series of transactions, it's necessary to complete the story, or it's inextricably intertwined with the evidence about the charged offenses. So what are y'all contending that it is?
All of them. So in as much as the arguments that are put forth in Ms. Abbasi's brief seems to focus specifically on
Your Honor, if I like that, I don't think there is a focus. I've never heard them say which theory they're proceeding under.
Right, yeah, you're saying it's not any of them.
Correct. I've never heard them say which of those three specific are.
So, Your Honor, I'll just tell Ms. Abbasi in the court right now. It is intrinsic to count one. Additionally, the conspiracy that it also is a part of is the YSL gang itself and the conspiracy that the gang itself makes up. I think we already presented some of the facts of the case to the court regarding the in concert action by five YSL members and two others of stabbing one person in defense of Mr. Ryan. And I know that the court has already read the indictment that describes, as the state alleges, the conspiracy itself being preserving, protecting, and enhancing the reputation, power, etc. of the enterprise with acts that include assault and threats of violence. And of course, I'm not reading the entire indictment, but in this particular case, it falls squarely under a number of actions that are intended to sort of circle the wagons around YSL members, show that they will stand up for each other and that they will commit violence on persons who they perceive as threats to members of YSL. Mr. Ryan, after he was indicted, there were several, at least one YSL member that we have listed as an overt act who makes assertions about Mr. Ryan and his murder charge and subsequent, I think, conviction. And there are people who perform acts during the course of his trial, at least one person that we believe were intended to intimidate a witness who was actually on the stand at the time. There are, by way of examples or analogies of other similar acts that are committed on behalf of YSL to show their solidarity. For instance, when Mr. Garlington is jumped, other members of YSL immediately jump in. We have evidence that when Mr. Copeland is jumped, at least one person in the courtroom now jumped, just jumped in just because. When it's one of them, they're going to come to their defense. The act itself wasn't.
Hear all of this argument, right under 404B, I'm waiting to hear which of these three categories it falls into. We're talking about two different issues here. Which of the three, and then 404.
It is not 404B, it is intrinsic.
It could be both. I mean, I guess it would be intrinsic, but I mean, y'all haven't offered it as 404B, right? And you don't intend to,
Right.
even if I rule against you on the intrinsic.
Well, if the court ruled against this, it would be a different argument that we'd be prepared to make on a different day, because that's not something we were putting before this court
Okay.
today.
All right.
So the actions of Mr. Ryan and the other YSL members in concert in stabbing Mr. Bussey when Ms. Abbasi asserts that they're not necessary to complete the story of the crime. This is our position, is that this conspiracy didn't stop at the jailhouse doors. It's ongoing. It's necessary that the jury sees that it is ongoing to show to them the truth and the whole truth that we believe that our evidence reflects, to show them the extent to which YSL members go in order to preserve and protect not only their name, their own, but their reputation. Mr. Ryan, Mr. Blaylock, Mr. Eppinger, Mr. Myrick, and Mr. McMullen are seen in the photo that, I don't know that the court needs to see it, but if it does, we can present it on Zoom camera to show the concerted action on their part in stabbing Mr. Bussey. This particular screen grab of the video doesn't have 5 knives in the air like one of them does. This was just them all holding him down. And for the purposes of just this hearing right now, we'll just call it State's Exhibit 465, RR for rebellious crime.
All right.
Your Honor, I guess I'm kind of more confused now because I think the state's purpose is they want to show that it's ongoing. So I don't know how they're using it to complete the story of the crime. If their version is that it's not complete and it's ongoing. I don't see how those two square. It's not an element that the jury has to find. The gang is continuing. The only thing they need to prove is that by the date of indictment, this happened. It really doesn't matter as far as what the jury needs to know for the state to meet the required elements. It doesn't matter whether the gang is continuing.
All right, but the state can prove if it chooses
They sure can.
that it's an ongoing conspiracy.
Sure, but that doesn't make it necessary to complete the crime.
Well, necessary to complete the story of the crime. And I guess the story of the crime is
Ongoing and continuous conspiracy that is YSL, its enterprise, and the members committing these particular acts and crimes for the purposes listed in the indictment under the definition of the conspiracy itself. And this act is not something that is obviously relevant to the issue of whether or not the defendants are or are not guilty of count 1 in terms of what we're alleging that they conspired to do. It certainly would be an overact under the definition of overact of count 1. So it would go to prove count 1 as to each of the defendants. It's therefore relevant, highly relevant as to that particular issue. It's presumptively, of course, the court is the gatekeeper, but under 402, because of its relevance, it's presumptively admissible. Under 403, Your Honor, there's nothing about it that is so substantially more prejudicial than probative, given its highly probative nature. Do you have the Zoom up here? Let me pull it up and put it on the Zoom. Considering it's coming just, we can't not in yet.
all right. Ms. Abbasi, can you remind me, and I don't know which one of y'all cited Murphy. Was that you, Ms. Abbasi? The part about integral and natural part of the witness's accounts of the circumstances surrounding the offenses, which factor did that go to?
I specifically did not cite that case. I did discuss whether it would be integral and natural part of what happened. I didn't cite to Murphy.
Okay, well, maybe it was just one I.
I did want to touch on one thing the state said, because I think we're getting into dangerous territory. state said that this act in and of itself could constitute an overact to support the verdict. Well, now we're talking about trying to prove the charges against the defendant based on something not unique.
Well, and you know, that's an issue that I've got written down here as something that y'all owe me law on, whether an overt act not listed could be the sole basis for a conviction.
Right, we do, and I think at some point.
Still waiting on that
No,
law.
we actually, I think at some point, and I might be wrong about this, but a contrary position was presented, and whatever case was cited, did not support that position. And we have affirmative, case law that we present in the form of a brief to the court.
All right, well, you go ahead and get that filed can you get it filed? When can you get it filed? By Monday?
Monday is
By
right.
Friday?
Monday is best.
All right, by Monday.
Your Honor, I can get to the court kind of the contrary case law that in the appellate, I know it sounds kind of, doesn't sound to square up, but it leads to an inconsistent verdict that perhaps some of the jurors found the defendants guilty based on facts which were in indictment, and perhaps some of them found the defendants guilty on
Oh,
facts which were not.
I mean, it's gonna be real fun when we get to the verdict form. I think that we're gonna have to get really specific about what they're finding. Because I don't think it can be that 6 found one and 3 found another and 2 found a third.
I think that this situation, this precise situation came up in Cotman, and I could be very, very wrong. I read it, I glanced over it briefly, but I think that the court found that given that the court instructed the jurors that their verdict had to be unanimous, that it did not present a reversible issue. The defense argued, or the appellants had argued, that there was no way to tell whether or not they all agreed on the same overt act. But in giving the court the brief that we intend to present, I think we can address that as well. I think that part is easily
All right,
addressed.
so that'll be 2 different issues. Can an overt act that's not listed in the indictment be the sole basis to support the conviction?
Mhm.
But then there's also, does the jury need to find unanimously this overt act, specific overt acts? Do they need to delineate which overt acts they are unanimously finding exist to each defendant?
Right, and I think that as it relates to our previous discussion that the court said we would address a little bit later, whether we number them or whatever, I just off the top of my head, I think that them listing an act that they found unanimously had been committed as to the defendants, I think would suffice.
Okay, well, if we all agree on that, then we don't need a brief on that.
Okay. So, I'm sorry, Mr. Boston.
Hmm?
I don't know if we made it to the 403 part on this.
No, we hadn't. We sort of got sidetracked,
I'll
but.
make sure I'm not.
All right, so we all agree that the jury is going to need to delineate. We unanimously find this overt act exists as to each defendant, right? I mean, we're going to break each defendant's counts out separately, and
I think that
I agree, but.
will, and to make certain that we present clearly to the juror, to the court, we do believe, yes, that the jurors have to make a unanimous decision as to each defendant and as to their overt acts, but as to whether the overt act it finds as to one unanimously has to, deal with the others.
I know. I mean, it can be wholly entirely separate as to each defendant. It needs to be a separate determination as to each defendant.
Yeah.
But for each individual defendant, does the state agree that the jury has to unanimously find 2 overt acts, one of which needs to or happen within the statute of limitations?
We agree they have to at least find one
Okay.
that happened within the statute of
And
limitations.
it needs to be unanimous that, let's say they all find overt act 66. whatever that is.
I believe it's safest that they find
Okay,
unanimously.
okay. All right,
And
then I don't
we-
need law on that because we'll just do that the safe way, whether it needs to happen that way or not. Okay, so back to, so I still will need by Monday whether an overt act not listed can be the sole basis for the conviction. And now we will go back to to what we were talking about, which is this
the intrinsic
allegedly intrinsic act.
So Mr. Ryan, given Mr. Blaylock is not here, but I will, since they were the two that were charged with the murder in one of the overt acts listed on the indictment, Your Honor, Mr. Ryan and Mr. Blaylock have entered a plea of not guilty to count one. And they are obviously charged with committing an act of violence against a person as alleged in the indictment in a manner that furthered the interests of the enterprise in the conspiracy. The three, I guess, points that Ms. Abbasi referenced in her brief were that the intrinsic or the act needed to arise out of the same transaction or series of transactions as the charged offenses necessary to complete the story of the crime, or is inextricably intertwined with the evidence regarding the uncharged offenses. And there is an or, so it does not have to be all three. So given that the jury will hear evidence of Mr. Ryan's and Mr. Blaylock's concerted efforts as they related to Mr. Holmes, they will hear evidence of Mr. Ryan's actions after the murder of Mr. Holmes. They'll hear evidence about their connections to YSL, but the fact that you have other members of YSL acting on behalf of Mr. Ryan to support him in a violent way against another person whom they allege only messed with Mr. Ryan's commissary, stabbing him just because he messed with Mr. Ryan's commissary, show the extent to which members of YSL go to assert their dominance, even in a situation like the Rice Street jail, and to protect one another, to show that you don't mess with one of our own. The argument obviously can be made by anyone. Yeah, this is not really what it's all about. But in terms of what the state is required to prove beyond a reasonable doubt to the jury, we alone bear that burden, given that it's evidence that there is violence committed on behalf of a member of YSL by members of YSL. We believe that it shows that the gang itself conducts itself in a particular way, and that the...
Okay, let's stop interrupting though. I mean, I assume she'll get to it at some point.
That the gang itself conducts itself in a particular way, and in Johnson versus State, a Supreme Court of Georgia case, whose site is 312 Georgia 481, decided September 21st, 2021, at Penn site 491, the court said that, of course, evidence is admissible as intrinsic when those three elements that we just mentioned exist. And they went on to expound and say, in applying this test, we have explained the evidence pertaining to the chain of events explaining the context, motive, and setup of the crime is properly admitted. If it is linked in time and circumstances with the charged crime, the defendants, the YSL members are all together. They are the ones that are included in or that participated in the stabbing of Mr. Bussey, are all housed together at the Rice Street Jail. The time frame is shortly after they're put together in that situation, all together in the Rice Street Jail. In this particular case, in Johnson, it has a set of circumstances that are not exactly the same as this, but we believe are analogous in many ways. In Johnson, of course, the appellant was charged with participating in criminal street gang activity, and the state's theory was that he was involved in the gambling house shootings with Blood Gang affiliate Porter and several unidentified assailants and another restaurant shooting. The evidence related, as the court found, to the Boulevard Place shootings added significant weight to that theory because the evidence was linked in time and circumstances with the charged crimes, and one victim was a member of a violent gang. We are not alleging that it is on all fours with our particular case, but to the extent that the Johnson court found it pertinent to say that the intrinsic act, or the act that the state alleged was intrinsic, added significant weight to the state's theory. For these reasons, we believe that that is analogous to our case as well, with 5 people, 7 total, acting in the same, overacting with an extreme amount of violence on behalf of one person whose connection, we believe, with the 5 YSL members is just they are all YSL members and they are acting protectively towards him. We have, we believe that that incident adds significant weight to our theory of the willingness of YSL members to participate in that enterprise in a manner involving violence to protect the dominance and the members of the enterprise and the gang itself. So the court found that even though the state didn't charge appellant in connection with the shooting, evidence of the incident was relevant to disputed issues in this case. So as Mr. Ryan has entered a plea of not guilty to count 1, conspiring to violate the Racketeer Influence and Corrupt Organizations Act by participating in YSL through these acts or conspiring to participate in them, then evidence of the involvement of Mr. Blaylock, Mr. Ryan, Mr. Eppinger, Mr. McMullen, and Mr. Myrick, all of whom are also charged in this indictment with a conspiracy. Evidence of Eppinger being charged with the shooting of an officer, evidence of Ryan, who was promoting YSL while in prison when Eppinger got a bond for shooting at the police, that Blaylock is a co-defendant on the murder of Mr. Holmes, which is an overt act here, and that Demise McMullen is a named co-defendant on the 2015 murder in the same indictment, shows how intertwined these people, this type of action, and this gang itself is with one another. They're all inextricably intertwined with the evidence regarding the uncharged offense, which is the stabbing of Mr. Bussey. So we believe that it satisfies the requirement of of being an intrinsic act.
Okay, which of the three?
The third one, we believe is the strongest in that it's inextricably intertwined with the evidence regarding the uncharged offense.
No, it's the charge. It should read the charged offense, right? I mean, it needs to be inextricable, right?
Yes, that the
Just
case
the
is
typo.
citing it wrong. Yes, thank
Yeah.
you.
So-
And that being count one, the conspiracy.
So how is it? And you think it's also necessary to complete the story of the crime, right? You're not asserting that's the same series of transactions as the charged offense, are you?
When the court says the same series of transactions, we believe that it's an overact, in as much as it could be considered an overact to promote, to support the gang. So in as much as it is or can be considered an overact for count one, and that it is gang activity, which it is.
All right, I'm not quite sure where I got this language, but I jotted down, and I think this is kind of the definition of inextricably, or an explanation of inextricably intertwined with the evidence regarding the charged offense, is that it is an integral and natural part of a witness's accounts of the circumstances surrounding the offenses in the indictment. Anybody
So
know if that's
So this-
that's as to, that's the explanation for what it means to be inextricably intertwined.
I think that came from Murphy.
That's Williams versus State, 302 Florida, 474. Cited in the brief.
What year is it was Williams?
2017, it's cited to on 11th Circuit.
Okay, and I think that language is also in a Court of Appeals case in 2020.
Okay, so, but I mean, if that's what it means for it to be inextricably intertwined with the evidence regarding the charged offense, how is that an integral and natural part of a witness's accounts of the circumstances surrounding the indicted offense?
So if the indicted offense is the conspiracy itself, and our witnesses talk about what they've observed, and we have evidence of what has occurred to further that conspiracy.
So would this be a witness who's being presented regardless, or is this a witness as to, I mean, obviously, if they're just coming in to testify about what happened in the jail, that wouldn't be the same thing, because I would have already made the determination, oh yeah, you can talk about this. Is there going to be any witness who there's no way they can give their account of how it is that any of these defendants is guilty of RICO without telling the jury about the stabbing?
No, we're not saying that. We're not
Okay.
saying that at all.
So then it's
No.
not inextricably intertwined.
But it does, it's an uncharged offense. That arises out of the same transaction, a series of transactions as the charged offense of count one. And the series of transactions is the acts of violence that have been described. One of the overt acts, as I said, is the murder of Mr. Holmes by Mr. Blaylock and Mr. Ryan, as we've alleged in the indictment.
And then how does
And
this
then-
arise out of that transaction?
The series of transactions. One of them is that the series of transaction is the set of actions that occur after, before, during, and after that murder itself. The series of transactions are the overt acts that help promote the purposes of the conspiracy. You have Woody Lee posting, I'm sorry, we made you a thug, so early little thug. You have people who are acting within YSL in support of Mr. Ryan. Mr. Ryan essentially talking about staying true to YSL regardless of his circumstances after the murder.
All right, and are all of those overt acts?
Yes, those that I just
alleged?
named are, yes, alleged overt acts. So the series of transactions, we would argue, is not a simple matter as on Monday, July 3rd, he got up, went to the store, bought a gun,
Yeah.
did that. It's
All right,
more
remind me
broad.
when the jail stabbing occurred.
It was February the,
Of,
February the 1st. January the 1st of 31st of 2023.
January 31st, 2023.
Yes.
And he'd been in prison, I guess, since 2019. When did they all get moved to the jail?
Mr. Ryan, I think, and Mr. Blaylock, those 5 co-defendants were, I'd have to look and see in Odyssey when they were transported, put together.
Roughly.
Thank
Okay,
you.
Approximately.
okay, that's, I mean, approximate is fine.
And also, Your Honor, under 104, and I get that we are still hashing out whether or not it's intrinsic. Once the court makes that determination, and we believe that it's clearly intrinsic regarding the conspiracy and the gang itself, there's another argument in support of its admission and use at trial that we make under one of the other rules of evidence, but not until we finish this part.
Well, I'm curious now as to what that would be.
Just that under rule. And I'm also curious about how the court will see or not see this position that I'm offering. But under 24-1-104, which specifically deals with the court handling the admissibility of evidence and the court's determination of it. 24-1-104E expressly says that this code section shall not limit the right of a party to introduce before the jury evidence relevant to weight or credibility. And so to the extent that part of our evidence, and it doesn't, speak to the weight of the evidence of the murder, but we believe that it substantiates and it corroborates our assertion via the overt acts that we have listed, that there is this conspiracy and that there are efforts that are continually made by members of YSL to support and protect one another and to advance the dominance and notoriety of the gang through acts of violence and assault.
All right, well, I do not think 104 has any bearing whatsoever on whether y'all can admit it before the jury.
So, okay, see, I know.
Okay, so that takes care of that one.
All right.
All right, do you have any, can you look, if you haven't yet, for any case law that deals with kind of a similar set of facts? Mr. Atkins is
How's-
shaking his head, yes.
Since
that
he is-
can look for that.
Oh, that is, we definitely can. I was just trying to make sure that I fully got what the court was saying. So in saying the same set of facts is, of course, speaking that
Similar set of
specific
facts.
as to, you know, somebody jumping somebody.
Well, I mean, yeah, ideally, if you could get that, that would be great. But no, it doesn't have to be that specific, but something that deals with gangs and or Rico, because what I hear you saying, or what I think I understand you to be saying, is that part of why this is intrinsic is because it's necessary to give a full story of how YSL is this ongoing criminal enterprise that uses violence to protect their members.
Right.
Am I understanding you correctly?
You are, and to assert its dominance. And in support of that, I also say that each of the members of YSL, Blaylock, Eppinger, McMullen, Ryan, and Fleetwood, had all, I believe all of them had been brought in from prison for YSL related offenses that they had been convicted of. Eppinger had been sentenced to prison off of a probation revocation for an armed robbery after he shot Officer Rogers. That was a YSL related incident. Mr. Fleetwood had been brought in from prison after shooting at Milton Howard, who at the time was driving YFN Lucci's vehicle with tinted windows. So the argument obviously could be made. He didn't know it was Mr. Howard. He knew it was an ops car. So all these people are all incarcerated because of YSL related offenses. And then you put them all in the same little area and they are once more acting as one single bullet against somebody they believe is a threat. But I can and we will look for a case on all fours with this particular set of circumstances.
Okay. I mean, I honestly think the 403 argument is easier than whether this is intrinsic, but yeah, I'll go ahead and hear that because maybe that'll be dispositive of this issue.
So would Mr. Basu, should I let her go first and sit down and see the floor? Does the court want to hear from the state?
It's in the brief, so I'll let you begin.
Well, I mean,
They have the burden. I'll give you the.
all you really say in the brief is it doesn't meet 403. You don't really say why.
Well, it's that it has to survive the balancing.
Okay, well, that's pretty clear.
To exclude what is a scan or cumulative over force, I think everything in here we're dealing with is scant and cumulative. There are, I don't want to get wrong, how many other acts in here the state can prove. These are necessary. I'm sorry. Is that on? That in the 403 analysis, the court should determine the prosecutorial lead, degree of similarity, and temporal remoteness. There are 191 overt acts. I think by the time the jury has heard all of those, they will have heard quite a bit of evidence regarding how gangs operate, examples of criminal street gang activity already. Quite a bit. I'm sure by November there will be more. Don't think there's any prosecutorial need to be coming up with these things additionally. There is plenty. Your Honor is able to exclude evidence which is cumulative, which is of course prejudicial, and a waste of time. I think that's where we're getting to in this circumstance. Clearly, there was enough evidence for the grand jury to return an indictment when
Well,
they heard this.
that's a lot lower standard.
It is, but if even that lower standard, it was met there, then I don't see how it suddenly become necessary here.
Okay,
Oh.
go ahead.
Judge, I've heard, and everyone I believe has heard a lot about the notion of the evidence being cumulative, as if there is a a certain amount of evidence, the state who bears this very high burden, I'm sure we'll hear told over and over again in closing arguments, that the state should be allowed to present to meet that very high burden. And I don't believe that cumulative evidence means proof of a different kind to show or to prove the same act. Just because the state has 150 ways to prove that the defendants conspired to violate the Ysl Rico statute, and the state, in an effort to ensure that each of its victims are adequately represented and that the jury hears sufficient evidence to allow it to convict each of the defendants, doesn't mean that the state should be constrained to putting up one piece of evidence, one picture showing somebody throwing up a gang sign.
Can I ask you a question? How many of your overt acts, if any, are assaults or aggravated assaults that are designed to either protect alleged members of YSL or promote or continue the, I can't remember the word you said, but the dominance, assert the dominance of YSL?
As it relates to Mr. Ryan, or just in general?
In general, since the argument is this is done to protect members of YSL and
To assert their dominance.
assert the dominance of YSL.
Okay. Since an overact does not have to be a crime, I'll just name them, of course. So number 9, where defendant Williams asserts in one of his songs, YSL.
No, that is not what I mean. I don't mean saying you're going to do something. I mean actual assaults on people.
We have Mr. Holmes's death is alleged by the state to have been a murder of someone that they believe to have been a member of a rival gang.
All right. So
Mr.
I'm sorry. I mean, I guess maybe, so because it's a rival gang, that would be dominance.
Yes.
And that's overt act, what, 79 or 69?
And I can also even be more precise there as I look for that number 79 or 69. Mr. Drinks's murder is alleged to have been a direct retaliation for the death of 2 people who were associates.
Your Honor,
Mhm.
I'm sorry, I'm just trying to
69.
I'm trying to
determine what you're
figure-
asking. Are you asking what the indictment alleges?
What,
Is-
yeah, overt acts.
Well, the
alleged
indictment,
in the
as I
indictment.
understand it, just broadly alleges that the overacts are done to that for those purposes. The indictment broadly alleges several purposes and doesn't delineate which overacts are designed to do what. So the answer, as far as I understand your question, would be all of them. They've
All right,
alleged
well,
all of them.
but I mean, I'm asking the state sort of what, I appreciate that position, but I think I mean it a little bit differently than that. And yeah, sure, they could end up saying every one of these does all of these things, but I'm kind of asking them to be focused on aggravated assaults, obviously, or worse, murder, that are for these very specific purposes.
So to answer your question about the number for that murder, it was overact number 79.
All right.
Also, the act on 4/28 by Mr. McMullen.
Overt act number
April
28.
April 28th.
Okay, yeah.
I'm looking at them in chronological order.
All right, that's fine.
The act by Mr. Garlington, Mr. Sledge, that act of shooting Miss.
Are we talking about things like rival gang type incidents?
My understanding of what the court said
I
is
just
what
want to know what the
acts
state's position is.
that were done to acts of violence done to promote either the
Either
notoriety or to
protect
protect.
the members of YSL or to promote the dominance of YSL.
So the shooting, we believe, by Mr. Winfrey of Lil Wayne's tour bus, which would have been a different one. It's encapsulated in 39 and 40. The shooting of Mr. by Mr. Murphy. On April the 12th.
Do you
Jackson
have any other
Montgomery.
overt acts where members or alleged members of YSL are basically doing a beat down of anybody because somebody from YSL got threatened or attacked?
We have other ones where they're shooting at other members, and we
Okay.
have where they, for instance, Mr. Kendrick and Mr. Arnold go out and plan to shoot somebody because someone jumped on Mr. Arnold in a club.
And that's an overt act?
It is. It is.
Okay.
Where also I think we have. Yeah. And they are, I think, Acts 41 through 45 is the
Okay.
This is the murder
All right.
on the 28th that or the aggravated assault that I talked about.
Okay. All right, well, y'all see if you can find me some more on point factually case law, please.
Okay.
And
Is the
I know
court,
y'all want a decision, but
that's so,
we're gonna come back to it yet again.
and Your Honor, in terms of the number of acts that we've enumerated in here, does the court want specifics or just the number?
Yeah, that's right. I mean, you've told me enough. That's fine.
Okay.
I mean, it's not like that's critical to my determination.
Okay.
I just was wondering if there were so many that this was something that would really be cumulative, but it doesn't sound like you really have anything that similar to this.
And as well, Judge, in terms of judging whether or not something is substantially more prejudicial than probative, it would have to, I think I've said it before, it would need to tend to sway the jury to convict the defendants on a ground different than something that has been alleged in the indictment. And given the allegations that we've made, we don't believe that this comes near that category of cases or circumstances. As well, Judge, I know the court is aware, but just to put it out there, 403 is, all of these rules of evidence are rules that favor admission. And so 403 is not to be used as been alleged to limit the state's ability to present evidence so much as it is a permissive statute that under very rare circumstances should be used to exclude relevant evidence. And the mere fact that a defendant may feel that, oh, the state has too much evidence against me, is not one of those circumstances that the courts have recognized.
So actually do speak about prosecutorial need.
To the extent that the argument throughout is that YSL is a gang, that everything that has been, that YSL is a music label, that everything anybody does is just their own independent act that has nothing to do with YSL from day one, from openings throughout up to even now. The assertion by every defendant is, and even the witnesses, I did it, for myself by myself. Every step of the way, the state is having to rebut that assertion that this is just me. I'm a criminal, but they aren't.
Okay.
So to the extent that there's no one here willing to stipulate that crimes are being committed by them and others with whom they've conspired to promote or on behalf of YSL, the state has a very strong need to present evidence of one, concerted efforts to commit the acts that we've alleged, to show the conspiracy between the defendants, and to show the purpose behind their concerted efforts.
All right, thank you.
Your Honor, I'm just looking here at some case law on prosecutorial lead to see what I have to answer Your Honor's question in that respect. It's in 403 itself and case law kind of more specific. I'm going to keep looking. I'm looking as I'm speaking here. As far as the prosecutorial need, I'm looking at cases where the need is there's no other source for that information, or at least limited sources of that information. I'm not sure how many hours of gang expert testimony the jury has already heard from about how a crime can further a gang or be part of a gang. I think the need to that point for on this principle, that there is no need. They've heard about it in depth. They will continue to hear about it. And as I said, I'm trying to look and see if I can get any more case law to specify if we have a level or a test for what need is.
All right, thank you. Well, if you find something else, feel free to just, shoot it over in an email that you share with everybody. That'll be fine. It doesn't need to, I mean, if you want to file it as a brief, that's also fine, but.
What I've got, just looking at some case notes here, prosecutorial need to induce a prior rape-related incident to show. Yes, I'm sorry. Explaining that the prosecutorial need to introduce a prior rape-related incident to show the defendant's intent was high because there was little other evidence supporting the charge of aggravated assault with intent to rape. That is a case, Kirby versus State, 304 Georgia at 483. And I haven't read that case. I'm looking at it. It is cited within Jackson versus State, 306 Georgia. 69 from 2019.
All right.
And could we get clarification? Is that a 404B case or a 414 case or 413 case, Kirby?
This is addressing a 403 issue.
Is it in the context of a 404B?
I don't know, but it's not a different analysis under 403.
As I said, I've not read the full case.
Yeah, I mean, it's fine. I understand the concept. Okay, let's set that aside and move on to something else. So there was I've got some notes of things we were going to circle back to. And one of them was a video of somebody smoking pot wearing a chain and it saying some things. BB maybe and Eppinger, some about robbing Smith. What was that about?
Yes, Your Honor, I believe that, Mr. Shard, we were supposed to narrow
It
down
was-
what
yeah.
videos the state we were going
Okay.
to admit. I sent that over, a few weeks ago, which ones we intended to use. I'm not sure we've been able just to talk about it in light of the last couple of weeks.
Okay, well, these are notes from back when we had that non-jury week, which I feel like has been a while ago now.
Yes, it was the week of August 19th, Your Honor.
Yeah, that's what I thought. So and I guess that was with regard to counts 27 through 29, maybe, is I think what I wrote down.
Yes, Your Honor.
So is that a video y'all intend to utilize?
We sent over, there are portions of that video we intended to utilize. I believe that the portion that was at issue is not a portion that we need to publish to the jury, Your Honor.
You're not going to show the jury?
Portions of the video. So the video is maybe approximately 5 to 7 minutes, and there's a portion, and I want to pull up my notes to see what I actually sent over to defense counsel as to what timestamps we intend to use, but a portion of it is relevant because it shows Mr. Eppinger and Mr. Beebe, the two people alleged to have committed this armed robbery,
Right.
on the phone, and a portion of that video, Mr. Eppinger appears in I think it's like a Instagram picture, an Instagram video, and Beebe shows him the chain. But there's another portion of the video in which Mr. Beebe is pointing a weapon at the camera. So there's just relevant portions, and we just haven't had the opportunity to discuss it, Your Honor. And I can let defense counsel know what date I sent over what the state intends to show.
All right. Does defense counsel still object to whatever portions those were?
Yes, I'll re-forward the email. August 23rd at about 1:55 p.m.
Question.
sent are approximately 5 clips that probably total together about 6 minutes of actual viewing. Is that about right, Ms. Hiller?
Yes, sir.
Okay, so in all honesty, we haven't had a group this is all acts involving someone that's not sitting here. And if we could have a couple minutes
Okay.
just to talk as a group to figure out
You may.
what our stance is. on
All
this.
right, and you know what? I may have y'all do that over the lunch hour. So the next thing I had us circling back on was, and I guess maybe these were from I don't know, we were going through maybe one of the sets of statements, because I've got like page 2, 523, 513. Oh, these were the wiretaps, maybe. Big Nick.
Yeah.
Waters Road. And then, oh, the comment about, yeah, this was the wiretap stuff, the flipping the car and laughing about that. And the state had said y'all were gonna narrow what you wanted to use from that and let us know. Do you recall that?
Just trying to remember flipping the car portion.
I don't know. It was there were 2 reference numbers. One of them was 513, one of them was 523. It was on that chart that you gave us, I think. On the second page of it, Garlington talking about how they came through and thought they were going to come back and they were going to get ready to light them up, laughing about Shamel Drink's murder and the need to re-up on drugs to sell. And I had determined that the drug part was in, but y'all were gonna look again at that other part. You said there was a non-hearsay purpose for it. Did did y'all ever go back and do that?
By lunch, we can.
Okay.
We'll be able to have an answer by lunchtime.
Yes.
Would you kindly just repeat the 2 reference numbers?
Yes, 513 or 523. On the chart, it's 513.
Thank you.
And then when we got to 1109 or 1124, there was an argument that that shouldn't come in against Nichols or Stillwell because they had already been arrested at the time and somebody was going to provide law on that.
Yeah, did that fall under the broader proposition that the court sort of touched on earlier regarding whether or not overt acts occurring after arrest could be used to prove the conspiracy itself, which would include people who have been arrested prior to the act being committed? If it did, we'd like to sort of address it.
I mean, I think y'all would need to establish that they're still a part of the ongoing conspiracy. listened to and did re-listen to the part that on the chart is 1974, and I think the other reference was 1999. And this was, I don't know if the argument was 403 there. Confusion, I think, was the argument. And upon re-listening, I don't find that to be a 403 issue. So that is admissible. That was about as far as we had gotten. And then, of course, we still need to circle back on the that one that we got bogged down with the nested hearsay with Garlington talking to Funk, who talked to Quay, who talked to Rel. So why don't we break for lunch? Y'all got some tasks to do over the lunch break. Do you have the material for me to look at? Yeah, it's not noon yet. It's about 1:45 but.
I just reached out to our other team members.
Okay.
To try and.
All right. Are you gonna email it or bring it as a hard copy or what's?
I'll email it. That makes it quicker.
Okay. All right. Please do that over the lunch break. Let's reconvene at 1:15.
Yes, Sharon, and I also put 460 on top of.
My copy of 460. We never did find.
I found our copy.
Okay, great. Thank you.
Choke no joke. We be back after lunch. All right. One. I just dropped a new video. Go check it out. Greg Caden gave Reggie immunity in the Diddy joint, and I'll be back.